Today's case puts mental health, family loyalty, and public safety on a collision course. Meet Mr. Scott, appearing for a competency review in a case so serious. The defense is already hinting at mental health court as a possible resolution. But here's the twist. The court has a history with him. He's been here before many times. His lawyer is pushing hard for a personal bond, citing medication compliance, family support, and a promise to attend treatment. The judge? He's listening, but his eyes are on the past, not just the present. And this hearing is about to show how quickly a plea for trust can crumble when history says otherwise.
The court, having reviewed the report, would find that the defendant is competent to stand trial. The defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is found competent.
Judge, I'll be asking this matter be set for a PCC, and Mr. Scott would like me to address bond as possible.
All right. Probable cause conference will be set for July 10th, 2025, 9 a.m.
Thank you, Judge. I've had a chance to talk to Mr. Scott about the situation, and I've relayed to him how serious of a charge he is facing. Mr. Scott is still asking that I seek a personal bond from on this case, Your Honor. Although the court does see that Mr. Scott is competent, Mr. Scott does indicate that he suffers from a variety of mental health conditions. He indicates that he would love to get this situation resolved. He would love to see his prosecutor's office potentially offer him a mental health court resolution. He says that he's not going to run from this situation. He has family support. He indicates that his mental state is in a much better place now than it was at the time of this alleged event. He indicates that he has a grandmother who is involved in his life and who will help make sure he attends any and all court dates. He indicates he will go to any outpatient or inpatient treatment that the court does require. He also has no objection to being on a tether. He indicates he's willing to just address everything that's going on in his life, Your Honor, that he will not be a problem for Your Honor should the court release him. He's asking that Your Honor consider a reduction in bond or a potential personal bond. But again, I have relayed to him how serious of a charge he's facing. But I believe that's what you want me to argue. Anything else? Mr. Scott says that he's on his medication now, and he's obviously much better when he's on his medication than he is when he's off his medication, and he will stay on his medication should the court allow him an opportunity to be released.
From a defense strategy perspective, this is the best possible framing. Mr. Scott is on his medication, claims a stable mental state, has family ready to support him, and says he'll accept strict supervision like a tether. This is exactly the package you pitch when you want a judge to take a risk on release. But remember, in bond decisions, the court weighs two big factors: flight risk and danger to the community. If the prosecution can convince the judge that Mr. Scott is still a threat, or that his past releases ended badly, no amount of family support will tip the scales.
And that the nurses in the jail have upped his medication in certain areas and have him on a shot and a pill form.
Yes.
And so his mental mind frame is in a better place, and he will do anything and everything the court asks, but he's asking for potential release.
Response.
I would ask that bond remain as currently set. I appreciate Mr. Easter's advocacy on behalf of his client. I'm struck by the language in the competency report. Mr. Scott affected a volitionally uncooperative response out during the evaluation process and attempted to feign legal knowledge, memory deficits, and symptoms of severe. Candidly, if you're uncooperative in the underlying competency evaluation, given his criminal history and the facts of this case, I believe that he is a danger to the community and as individuals.
This is the pivot point. The prosecutor concedes competency, but paints a very different picture. Forget the promises. They say, look at his criminal history. Look at the facts of this case. Calling a defendant dangerous in open court is not just rhetoric. It's laying the legal foundation to deny bond. And in bond hearings, credibility is currency. The prosecution's argument here is essentially, Judge, we've been down this road before, and we know how it ends. For viewers, ask yourself, if someone failed to follow court conditions before, would you give them another chance?
Mr. Scott was in custody. I took a chance, released him. He did not make it a week before this came up. Mr. Scott was arrested.
Directly, Your Honor, if you'll.
Go ahead, Mr. Scott.
Listen, Mr. Simpson, I know you kind of keep, going back in the past, right? But this is my life. You know what I'm saying? My grandma's here. My family's here. People are making me look bad. Even a competency hearing, they're making me look bad. I answered everything what I was supposed to answer the right way, and the prosecutor is saying I was I wasn't cooperating the correct way, and I was. It seems like I had to take 2 competency tests. And the first one, he just said what he wanted to say. I'm asking if you release me today, because I got to go see Slay today. They said if I do get released, they're going to follow the same recommendations you will follow if they put me on tether, if they put me in. You never put me in no classes. You never ever put me in no classes or try to do anything like that. I want my days to be filled. If I'm on tether and I have a curfew, I want my days to be filled. I be with my auntie, stuff like that. I go to classes. I go to Don Farms. I need this. I need help. I have a drug problem. I never addressed it like this. But after my sister died last year, she died. She had passed away at 23. I went crazy. I didn't understand half of the things. She had heart failure. It's my grandma. She's 70 years old, something like that. What it happen if you keep me in here and then she just something happens? No.
This is one of the most emotional moments. You can hear the frustration and desperation in Mr. Scott's voice. He talks about his grandmother, his late sister, his drug problem, and a desire for structure and treatment. In another courtroom, with another track record, this might work. But here's the reality. Judges remember when they've taken a chance and been burned. The judge points out that the last time he released Mr. Scott, it took only 8 days before a new, violent allegation, pointing a gun at someone, landed him back in custody. Emotion may sway sympathy, but it rarely outweighs public safety in violent cases.
Listen,
Mr. Scott, no, you listen. No, you listen.
but
I'm done. I let you out. I gave you a chance. I've given you numerous chances. Saying that anybody's trying to make you look bad, I don't have to go to the past. I let you out. You don't make it 8 days. And now I have you involved in a crime that involves pointing a gun at another person. I'm done.
what do you mean?
Listen,
can you just let me
motion for bond reduction denied, bond will continue.
Thank you, Judge.
And there it is, bond reduction denied. The judge makes it clear. This isn't about making Mr. Scott look bad. It's about hard facts. A history of missed opportunities, a fresh violent allegation, and a lack of trust that supervision will work. In the end, no matter how compelling the personal story, the court's first duty is to protect the public. This case is a powerful example of how past behavior can overshadow present promises in the justice system. If you found this case as eye-opening as we did, hit that like button, share your thoughts in the comments. Would you have taken a risk and granted bond? And don't forget to subscribe for more courtroom breakdowns where the stakes are real and the decisions are final.